Welcome to this week's recorded lecture. This is week 2, where we will cover the issues of relevance. And the pages from your casebook, page 75 to 109. This lecture will go through the cases from this week's reading. The main rule of evidence that these cases are dealing with is FRE 403, excluding relevant evidence. You can see from this slide that there are a few reasons why a court might decide to exclude otherwise relevant evidence if its value is outweighed by the danger it can cause for these things listed here. Unfair prejudice, confusing the issues, misleading a jury, undue delay, wasting time, or needlessly presenting cumulative evidence. The first case that we'll cover today is Knapp v. State. This is a Supreme Court of Indiana case from 1907. The appellant in this case is appealing a conviction of first-degree murder, where a motion for his new trial was overruled. At trial, the defendant testified that he was acting in self-defense. The defense argued that the defendant feared the deceased, the man that he allegedly killed. And he testified that he feared the deceased because he had heard, just before the killing, that the deceased had clubbed and seriously injured someone. When the defendant was asked on cross-examination who had told him that, the defendant said he couldn't remember and was unable to answer. The prosecution then introduced evidence that the old man was not, in fact, beaten by the deceased, instead dying of alcoholism with no signs of a beating or injury on his body. The issue here is the admissibility of the evidence that the state tried to introduce, showing that the old man was not beaten to death. The defense claims that this evidence is irrelevant because what they were trying to show was not the truth of that assertion, that the old man was in fact beaten to death, and that had no bearing on whether or not that was what the defendant was told by someone. The prosecution argued, on the other hand, in this case the court agreed, that the truth of what happened to the old man was relevant, and it was relevant to the credibility of the defendant's claim. The assumption is that if the underlying report is false, that the old man was not beaten by the deceased, then it's less likely that the defendant actually heard this false report and more likely that he was lying on the stand. The holding in this case was that the trial court judgment in admitting this evidence was affirmed. The risk they felt to the jury would be that the jury would be prejudiced by this evidence of the defendant's mistaken belief was low, and low enough that the evidence should be admitted. At trial, one of the officers testified that the suspect in this case had made a quick movement as if reaching for a weapon. So wouldn't then evidence that there was no weapon take away from the credibility of that officer's testimony? Wouldn't it make it less likely that that quick movement ever happened? A jury then could weigh that officer's testimony against the knowledge that there was no weapon, and maybe that would lead them to think the officer, again, like in the previous case, was potentially lying on the stand. The next case we cover is Old Chief v. United States. This is a Supreme Court case from 1997. This case is about a federal statute that prohibits possession of a firearm by anyone with a prior felony conviction. The government can prove this by introducing a record of judgments or any other evidence of the offense, and that being the prior felony conviction. In this case, the defendant, Old Chief, was charged with possessing a firearm while having a prior felony conviction. The issue here is whether the district court abused its discretion by ignoring an offer by Old Chief to concede that he did have a prior felony conviction and instead introduced the defendant's full record of prior convictions. And the Supreme Court held here that yes, the district court did abuse its discretion. The defendant's prior felony was for assault causing serious bodily injury, which was similar to what he was being charged for currently. He asked that the government be prohibited from revealing to the jury the nature of this previous felony, and he also offered to stipulate to the fact that he had a prior qualifying felony conviction. The prosecution refused to stipulate with the defendant. The trial court then allowed the prosecution to show evidence of the nature of that prior felony conviction to the jury. The Supreme Court held that this was an error to allow the government to introduce that evidence. The danger of the prejudice that the jury would use that prior conviction to show that it was maybe a crime in the defendant's nature was outweighed by the probative value of the evidence, and the case was remanded. The issue that we are dealing with here is, again, FRE 403, where evidence may be admissible if used for one purpose, but inadmissible if used for another. So an example of this is hearsay and hearsay exceptions. So an out-of-court statement that may be admissible to show, if it's used to show its effect on the hearer, but not the truth of the matter asserted. So an out-of-court statement is hearsay and inadmissible, but there are many exceptions to hearsay that we'll get to in later weeks, that if maybe this out-of-court statement is used to show the effect on the hearer, it could be admitted for that limited purpose. So how does a judge deal with this issue? How do they decide what relevant evidence to admit and for what purpose? In Old Chief, the court gives us a guide of how a judge should go through considering admitting evidence. So first, a judge looks for what proper purpose, if any, could the evidence be used. Then they must consider what forbidden purpose it might be used for. Next, is there a different form of evidence that could be admitted that could accomplish the same outcome without as much risk for it being used for a forbidden purpose? And then when considering that alternative, does the prejudice substantially outweigh the probative value? Our next case is Fields v. City of Chicago. This is a United States District Court case with the Northern District of Illinois in 2018. The plaintiff is a man who was shot by the Chicago police, and he brings this civil rights action against the city and the police officers. The plaintiff here is claiming that he was shot without provocation and that the officers mistreated him. The officers are contending that the plaintiff lunged at them with what they thought was a gun and that they feared for their lives. In your casebook, this excerpt is going over motions in limine by both parties, which is a motion by a party to exclude evidence from trial. So both parties can make these motions prior to trial, which is asking a judge to exclude certain evidence for different reasons. We'll go through the different motions in limine for each side, and then we will go over the judge's ruling on those motions. So plaintiff's motions in limine number 1, the court granted. So this means that they are excluding evidence that the defendant police officers would suffer a negative professional consequence from an adverse outcome at trial. The court granted this, saying that the defendants could testify that they would be personally liable, but then the plaintiff could counter and present evidence that the city would indemnify them. Plaintiff's motions in limine number 2, the court also granted, which excluded evidence of gun violence in Chicago. The court felt that this was too general of evidence and had little to do with the actual circumstances around this shooting and the reasonableness of this officer's conduct. Plaintiff's motions in limine number 5, the court allowed evidence that plaintiff's home, where the shooting occurred, was a high crime area. So think about why number 2 on the last slide and number 5 here had different rulings. You would think they would be the same. So in number 2, the court would not let in evidence that Chicago as a whole might be a high crime area, but did allow evidence that the area around plaintiff's home was a high crime area. It could be that the judge felt that this was a little more tailored to the facts of this case. In plaintiff's motions in limine number 12, the court granted as well. This barred evidence of plaintiff's past gang membership because the prejudice outweighed the probative value. So consider instead that what if the officers were aware that plaintiff had gang affiliations? The main issue at trial here is whether the officers' actions were objectively reasonable given the circumstances. So would a gang membership, if the officers knew of it before the shooting, be substantially probative? And then, if so, could this evidence be conditionally relevant? And this means that relevant only if there was also evidence that the officers knew of the gang affiliations before they shot at the plaintiff. In defendant's motions in limine, so this is the officers, number 4, 5, and 15, the court granted these in part, which excluded evidence of a general code of silence among police officers and that the Chicago officers attempted to cover up police misconduct. The court felt this evidence was too general and not probative enough to overcome that prejudice. What they did allow was proof that these particular officers attempted to cover up their own wrongdoing in this case. The court also precluded evidence of an insufficient investigation by individuals that were not involved in this incident. In defendant's motions in limine number 7, the court reserved ruling, which means the judge didn't make a decision prior to trial. And this motions in limine was trying to exclude evidence that the shooting officer should have used an alternate method of force. So the court would not allow evidence of an alternate method if it was based on hindsight evaluation. In the defendant's motions in limine 13 and 14, the court granted these, and this was excluding evidence regarding training and supervision of the officers and misconduct in other cases. Again, the judge wanted to tailor the evidence to this specific crime and these specific officers. In defendant's motions in limine number 19, the court reserved ruling on this as well. This sought to bar argument that the alleged misconduct was racially motivated. So the court felt that racial motivation was not relevant to whether the officer's conduct was objectively reasonable, but that it might be relevant to a punitive damages request. Would you agree with this? So, would proof that the officer had a racial bias towards the plaintiff make it less probable to the jury that these factors would allegedly give him an objective reason to fear the plaintiff, or was that a strong enough reason to cause the shooting? It's something that potentially the jury should consider, but the judge in this case felt that it was not relevant. Now our next case is Bailu v. Henry Studios. This is a United States Court of Appeals for the Fifth Circuit in 1981. This was an auto negligence case. Then the trial court excluded results of a blood test showing that the decedent in the case was heavily intoxicated at the time of an accident. The issue in the case is whether the trial judge erred in excluding this evidence of the blood test. And should the credibility of this evidence be a decision for the jury instead of the judge? The holding was yes. The court reversed. The trial court should not have excluded the relevant evidence of the blood test. The issues this case dealt with was, 1, who decides these foundational facts which go to the relevance of the evidence, the judge or the jury, and also dealing again with FRE 403, the prejudicial effect versus probative value. The defendant argued that the results of a blood test showing that the decedent was intoxicated at the time of an accident should have been admissible. The trial judge, on the other hand, excluded the evidence because they had testimony of a witness that said they treated the decedent shortly after the accident and didn't see any signs of intoxication. So in this case, the judge decided to believe that witness rather than the results of the blood test and excluded the blood test from the trial. The question being, should this have been a decision for the jury to judge the credibility of the witness versus the blood test? The court held that the value of the blood test was outweighed by its prejudicial effect, and the appellate court reversed. And so we ask why. They reversed, saying that the judge overstepped his role by taking that decision away from the jury. The appellate court states that the judge should just assume the testimony is true, including the blood test, and then weigh the probative value versus the prejudicial effect. So here, if the evidence of the driver being drunk was accepted as true, then balancing that probative value versus the prejudicial would be in favor of admitting the evidence. Next in your casebook is a series of hypos. We will go through these during class, so please be prepared to review and answer the hypos in small breakout rooms, and then we will present back to the class as a whole. The next case we'll cover is Holmes v. South Carolina. This was a United States Supreme Court case in 2006. The defendant was convicted of murder and other crimes, and forensic evidence strongly pointed to his guilt. The defendant argued that this evidence pointing towards his guilt was contaminated and that he was framed. He also sought to introduce evidence that indicated that another man had committed the crime. There was a South Carolina evidence rule that excluded third-party guilt, and so he was not allowed to bring this evidence at trial. The issue here is whether this defendant's constitutional rights were violated by this evidence rule. So the holding was yes. The Supreme Court held unanimously that the defendant's constitutional rights were violated by excluding the evidence. So states can have many valid reasons for excluding evidence, but this case was extreme. The Constitution guarantees a criminal defendant rights at trial that state courts cannot take away. This includes the ability to have a meaningful opportunity to present a complete defense. In Clark v. States, this is a Maryland Court of Appeals case from 1993. The defendant in this case was convicted of rape and resisting arrest and assault. A witness was testifying to the chain of custody of a blood sample, and on cross-examination, the defense counsel asked this prosecution witness a question, and then the answer was harmful to the defense. So in this case, the witness was testifying that the defendant was a suspect in another rape case. The defense counsel then wanted to continue to question the witness to show that this DNA evidence actually exonerated the defendant from that other rape charge, but the trial judge refused. The issue here is, should the defense counsel have been allowed to continue to question the witness to cure that harmful testimony? And the court here held that they should have been able to continue to question the witness. And this questioning would have otherwise been inadmissible, but because of the doctrine of curative admissibility, once that witness started to testify, the defense counsel should have been allowed to then cure the harmful testimony. Again, once the witness testified and opened that door to discussing a prior rape charge, the defense was then allowed to cure the damage with evidence that otherwise might have been inadmissible. And that is all the cases for this week's reading. So next week we will cover character evidence.